This isn't your average stolen car case. This is a rare moment where the courtroom becomes a reality check. Today, we're watching Daniel Balderas, a 19-year-old caught in a felony case involving the unauthorized use of a vehicle, but the drama goes way beyond the charge. This hearing exposes what happens when a young defendant meets a judge who's not afraid to speak the brutal truth. From plea deals to GED ultimatums, to a moment that leaves the courtroom completely speechless. You don't want to miss this one. We'll break down everything. What deferred adjudication really means. Why? The judge forces a life lecture mid-sentencing, and what this case tells us about second chances in the legal system. Stick around, because the twists in this case are more personal than legal, and by the end, you'll be asking yourself, was justice served? Or was this just tough love in a black robe? Let's get into it.
Court is calling 2024 CR 2985, State of Texas versus Daniel Balderas. Can I have parties that for the record for the state? Defense?
Elizabeth Settle for the defense.
Are you Daniel Balderas?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your
Court will find that the state is in compliance with discovery. Mr. Balderas, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, sir.
Did you review the court admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with unauthorized use of a vehicle? That's a state jail felony.
All right, let's break this down. Daniel is facing a state jail felony for unauthorized use of a vehicle. That's not just joyriding. That's a felony punishable by up to 2 years in the state jail and a $10,000 fine. But here's where it gets interesting. Instead of heading straight into sentencing, the judge is considering deferred adjudication. That's a type of probation where if Daniel behaves and completes the terms, he avoids a formal conviction on his record. It's essentially a second chance, but one wrong move, and he's back in front of the judge with everything on the table. Question for the comments. Do you think someone should get deferred adjudication at 19 for a stolen vehicle charge? Or should consequences hit harder the first time?
Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am. I just.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your
Mr. Balderas, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $500 fine. State recommends deferred adjudication. This is to run concurrent with County Court Cause number 733375. There's to be restitution, if any, to Maybelline Cortez. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes.
This part right here, it's huge. Daniel is waiving his right to appeal, meaning if anything goes sideways, he can't fight the sentence later on. The judge makes it crystal clear, if he messes up, that deal is gone and he could face real time. It's like walking a legal tightrope with no safety net. What's wild is how casually he answers, yes, ma'am, to everything. Like he's ordering lunch instead of risking his future. Is he being respectful, or is this someone who doesn't fully grasp what's on the line? You decide.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
None.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 2 years. There be a TAP evaluation and 120 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Contest, ma'am.
State any evidence.
State all for state exhibit one and all evidence.
No objection.
All right, and state, have you spoken with the complainants?
Judge, we made attempts to reach the complainants, but so far I don't think.
All right, thank you. You may be excused. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am. I do.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation and testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, we just ask that you follow the plea bargain.
All right, how old are you?
19, ma'am.
All right, why are you riding in stolen vehicles?
Just
Hugh, I'm just hanging with the wrong crowd. And the judge doesn't let that slide. She flips it right back. You are the wrong crowd. This isn't just a judge dishing punishment, tits. A judge calling out a mindset. You can see it on Daniel's face. He thought that excuse would work. But judge isn't buying it. This is accountability in real time. Sound off in the comments, was this a necessary wake-up call? Or did the judge go too far?
hanging around the wrong crowd, to be honest.
No,
ma'am.
you are the wrong crowd. That's what other people would say. The co-defendant or the other suspect who's with you, Sandoval, his family would tell me he's hanging around with the wrong crowd, and that would be you. So what are you doing with your life?
To be honest, I'm just trying to finish school and get a job and just do good.
How are you just trying to finish school? What are you doing?
Well, right now I'm looking for like schools to be able to get my GED and my high school diploma.
You can find that anywhere on the computer. If you can drive around in a car that doesn't belong to you, I'm sure you can go on the computer. Do you have a phone,
Yes, ma'am.
a cell phone?
Yes, ma'am.
There is, I'm sure there is Google or whatever on that cell phone. You can Google, there's places throughout San Antonio where you can get your GED.
Yes,
Why didn't you finish school?
and I was in juvenile, didn't get a chance to finish it.
All right, do you have any children?
No, ma'am.
Okay, that's a good thing. You need to get your life in order. You understand?
Yes,
Who do you
ma'am.
live with?
My mom.
All right. This is what the court will do.
Now we get to the real terms of this deal. Daniel gets 2 years deferred adjudication, 120 hours of community service, random drug tests, and employment requirements. But here's the twist: if Daniel gets his GED or finishes trade school, the restitution gets waived. That's not just a sentence, it's an opportunity for reinvention. This is what some legal experts call constructive sentencing, where the system doesn't just punish but tries to redirect. Let us know, should more judges offer this kind of deal, or is this letting offenders off too easy?
There is a $500 fine that will be probated. Court is going to sentence you to 2 years deferred adjudication. This is run concurrent with County Court Cause number 733375. There's to be 120 hours of community service restitution. That will be waived if you obtain your GED or if you're in some sort of trade school and you graduate. Do you understand?
Yes, ma'am. I could.
There's to be regular reporting.
6 months clean at least, that's what Daniel claims. But the judge isn't taking any chances. She orders random UAs, a UA hotline, and even talks levels and thresholds. This is where the courtroom turns clinical. Every choice Daniel makes now will show up in lab results. But pause and reflect, he's 19. No kids, still with his mom, and now staring down state supervision. Do you think this structured accountability will actually help him stay clean?
By Zoom or in person. If you're drug tested today, what are the results going to be?
Clean.
All right, when's the last time you used?
Months. Since like six months.
And using what?
Marijuana.
All right, there's going to be regular random UAs. And make sure he's tested for levels if he comes out positive. If he is positive, what we're going to do is there's going to be the UA hotline if he's positive. And he's going to stay on that UA hotline until he presents with a negative UA. And then we'll go back to regular random UAs. There's going to be proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. And let him take the theft course. And there's to be field visits 1 time per month until he is employed or obtaining his GED. Probation, is there anything else he needs? Is there anything else you need from the court to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
If you want things, get a job. This is no longer a court session, it's a life intervention. The judge lays it out plain. Your things won't follow you to the grave. She even jokes about people being buried with their cars just to make her point. This is the kind of courtroom moment that sticks not because of legal precedent, but because it hits real. It's clear the judge sees some potential here, and maybe that's why she came down hard. What do you think? Was this tough? Love the push Daniel needed, or just courtroom theatrics?
All right, we can go off the record. Here's the thing, you're young. Let me just tell you something. If you want things, go out, get a job so you can afford things. But at the end of the day, when all of us die, guess what? Your things cannot go with you. Although I've heard of people being buried with their car, which I don't know why you would do that, because it costs extra, I'm assuming, to have a car for you to be buried in.
So let's recap. Daniel Baldera is 19 years old, accepted a plea for unauthorized use of a vehicle. The court deferred adjudication for 2 years, tied to strict terms, GED, or trade school, community service, employment, and random drug tests. This case wasn't about a stolen car, it was about whether the system can reroute someone before they spiral further. And in this case, the judge didn't just hand down punishment, she delivered a challenge. Will Daniel rise to meet it, or end up back in front of the same bench with fewer options next time? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We've got more real cases, real drama, and real justice coming your way. Stay tuned.